We are now in the post-commencement transactions. So after commencement date, the general rule is that the funds and properties of the debtor should not be used or disposed of, okay, except if that use is in the ordinary course of business of the debtor and when the use of the funds or property is to finance the administrative expense. So you saw earlier that there are certain authorized administrative expenses. So that this must be paid using the assets of the debtor. So can there still be sale of the assets of the debtor if it is in the ordinary course of business? Okay, definitely pwede siya as an exception. General rule, no. But if you are able to meet the requirements in section 49, then there can be sale of unencumbered assets, meaning these are assets not subject to any lien or any other claim. So under section 49, you're able to comply with this rules, with this section. There can be an authorized sale of unencumbered assets. So this will be upon motion filed by the receiver with notice to the debtor and the creditors. And this sale, okay, must happen because of either the nature of the thing to be sold or other circumstances, like it is perishable, is costly to maintain, susceptible to devaluation, or the property is in jeopardy and must be disposed of right away. How about encumbered assets? Excuse me, guys, 5 minutes lang. So there should be there can be a sale of encumbered assets and also third party assets held by the debtor. Okay, but the third party asset held by the debtor can be sold if there is a security interest pertaining to the third parties under a financial credit or other similar transaction. So also the sale must be upon motion of the receiver. And the sale can only happen if the affected owner or secured creditor have given their consent and the sale is proven to be necessary for the continued operation of the debtor's business. Or if the debtor was able to make substitute arrangements. So nihatag siya, gi-replace niya og laing lien or security. So if the debtor also has prior authority to sell those assets pursuant to a trust receipt or na sila consignment agreement, then there can also be a sale of that encumbered asset or third-party asset. So this time, if the debtor had this prior authority to sell, the sale can be made upon motion of the debtor and there is conduct of a hearing. So in both cases, when there is a sale, guys, of encumbered assets, it must be shown that the sale is necessary for the continued operation of the debtor's business. How about the assets of the debtor, but it is held by third parties? So, si debtor ani, possible nga nagprinda siya, either real properties or chattels. And that asset must be turned over to the pledgee. For example, if there is a contract of pledge, then the rule is that the properties should not be transferred, conveyed, or disposed to persons except only to the debtor. So whoever is in possession of the asset of the debtor must not dispose it except in favor of the debtor. And if there is any disposal that can happen, it should be with prior approval of the receiver. So the receiver here is given the option of whether or not ipa-surrender, ipa-return niya ang property or authorize its disposal, or just allow the third person to continue in possession of the asset. How about loans? Can there be new credit transactions, credit arrangements entered into by the debtor? So this is only upon recommendation of the receiver, guys, and always with the approval of the court. So there can be post-commencement loans. How about those assets that are subject to rapid obsolescence, depreciation, and diminution of value? So assets subject to wear and tear. Okay, how is this handled in the rehabilitation proceedings? So the secured creditor can make the necessary motion in court to order the debtor or the rehabilitation receiver to make sure that these assets will not depreciate or will not be worn down due to the pendency of the rehabilitation proceedings. But if it cannot be preserved, if the asset cannot be preserved despite efforts of the uh, court or the receiver or the debtor, then there can be authority for the foreclosure of those assets. I-foreclose na lang siya sa katong whoever creditor is has a security interest over that asset, or it can be otherwise sold or disposed of in accordance with the approval of the court. Kay dugay biyaning rehabilitation. You'll find later in the termination stage that the proceedings will terminate upon the success or the failure of the rehabilitation plan. So there is the danger that the assets of the debtor can be will depreciate. So if there is any disposal of the unencumbered assets or properties of the debtor not in the ordinary course of business and after the commencement date, then this can be rescinded or nullified. Okay?
Yes, attorney.
Okay.
Wala. Grabe kayo kaog. Ikaw yun. Diba?
Okay, so this is another clawback provision. Clawback meaning mabawi siya because that sale was already made after the commencement date and it was not in the ordinary course of business. So even though it can be recovered, there must still be a motion for the rescission or nullity of the sale as well as conduct of a hearing. So here are the court authorized transactions. If the transaction is related to any of these, paragraph A to F, then that is court authorized. So that is a valid transaction. So the rights of creditors with respect to their securities will not be affected by the stay order or commencement order. Question: does that mean that they can foreclose on the securities that they have despite the stay order? What do you think, guys? Naa sa slide off. Di siya ka-foreclose. Maski secured creditor siya. So, not affected ang iyang security interest, but it cannot be enforced during the effectivity of the stay order. So, suspended ang iyang right to enforce the security or lien. So, most in cases decided by the Supreme Court, okay, you'll encounter there creditors who argue that the security belonging to them is not included in the rehabilitation proceedings. So diha ang lalis nga di man ni appeal sa rehabilitation. So that's one of the way in which a secured creditor can enforce the lien despite the pendency of the rehabilitation proceedings if the creditor can prove that the property is not necessary, okay, or not included in the rehabilitation. So of course, you need to have the recommendation of the receiver that the property, the secured property is not necessary for rehabilitation. If there is recovery, if the court approves, okay, the foreclosure on that security, and after foreclosure sale, there is a balance received more than the amount owed to that creditor, that balance will belong to the estate of the debtor. But if deficient siya, na ay deficit, utangan gihapon si debtor despite the foreclosure, then that will be registered as a claim in the rehabilitation proceedings. So another very technical topic. How about the secured creditor? Secured unta siya, but he is considered as lacking adequate protection. Why? Because the debtor, who is also the petitioner here, kung voluntary rehabilitation, the debtor fails or refuses to honor a pre-existing agreement, or the debtor fails to take commercially reasonable steps to maintain the property, or there has been great depreciation of the property. So, kung existing ni siya, there is a secured creditor lacking adequate protection. So, what is the remedy available to this secured creditor pero insecure dahil siya, no? So, the court on motion or motu proprio may remove the claim from the coverage of the stay order and the court can direct that insurance be procured, okay, to maintain the property or to make or provide additional or replacement security. Kung inadequate na ang security ba? So, this is also a good question sa bar. What is the remedy of the secured creditor if the property over which naon ta siya security is not well maintained? So, pwede siya mo file og motion sa court to seek this remedy from the court. So, the court can act upon the motion of this secured creditor lacking adequate protection as long as the property is determined to be not required for rehabilitation. If the property will be otherwise utilized for the rehabilitation of the debtor, then ma-deny ang motion ni secured creditor. So post initial hearing, after nahitabo na ito tanan na discuss so far, the court is now tasked to determine whether or not the petition, whether or not to give due course or to dismiss the petition. And this is reckoned from the time that the receiver will submit the receiver's report. So a petition is given due course if the debtor is insolvent and there is substantial likelihood for the debtor to be successfully rehabilitated. The court will dismiss, however, the petition if the debtor is not insolvent. The petition is a sham filing to delay enforcement of the rights of creditors. If there are materially false or misleading statements in the petition and its attachments, and if the debtor has committed acts of misrepresentation or in fraud of its creditors. So, very important ni siya na grounds, guys. You should memorize this dismissal because most bar questions will ask you, ani, will you deny or give due course to the petition for rehabilitation? Yan, sama niya pag-answer. Kung mo ka ba, ani. But there is also another route which the court can take after it receives the rehabilitation report, the receiver's report. So the court can convert the proceedings into what kind of proceedings can it be converted into? Pwede siya ma-convert to liquidation if it is found that there is no substantial likelihood that the debtor can be successfully rehabilitated. Also, pwede sad ma-convert ang proceedings to rehabilitation if after the period of rehabilitation, the rehabilitation utterly failed. So, converted na siya into liquidation. What happens if the petition is given due course? Then the receiver will now shift gear, change gear na siya. And ang focus na ni rehabilitation receiver is to work on the rehabilitation plan. So, take note that at the time of filing of the petition, okay, dapat if it is voluntary rehabilitation or involuntary, there should already be a proposed rehabilitation plan. So the receiver here is not working from square one. Nana na siya kasugdan. So from the time that the petition is given due course and within a period of not more than 90 days, therefrom, the receiver should submit a rehabilitation plan. Of course, if the case is dismissed, the petitioner, if it is the debtor in voluntary rehabilitation or the creditors in involuntary rehabilitation, are liable to pay any damages and other cost of suit if it is dismissed. So we're now in the pre-confirmation stage. So another 5-minute break because I will pause the recording para di ka siya taas. Okay lang ninyo nag-break ta guys.
Good attorney.
Yes, attorney. Yes, attorney.
Way klase, ganahan ng estudyante ana. Wa mo ka ba o mga teachers ganahan sad may way klase. So see you in 5 minutes. Okay, let's continue. So pre-confirmation stage. Question. What is supposed to be confirmed? Why is there a pre-confirmation stage? So as already alluded to earlier, we're now concerned with the rehabilitation plan. So pre-confirmation stage refers to the activities happening in the rehabilitation court for confirmation of the rehabilitation plan. So preparation of the rehabilitation plan. What is the rehabilitation plan? So it's a plan for the financial well-being and viability of an insolvent debtor. And this insolvent debtor can be restored using various means, including but not limited to debt forgiveness, debt rescheduling, reorganization or quasi-reorganization, dación en pago, debt equity conversion, and sale of business or parts of the business as a going concern, or setting up of a new business or a new business entity or other similar arrangements as may be approved by the courts or creditors. So here are the important contents of the rehabilitation plan. There should be assumptions made. And what assumptions are we referring to? Assumptions on whether or not the current assets less the liabilities of the debtor can still finance or make the rehabilitation of that insolvent debtor possible. So they need to make predictions on how to accomplish that goal of rehabilitating the debtor. So there is the required liquidation analysis. There will have to be an assumption on whether or not the creditors will be better off if the debtor proceeded to liquidation instead of rehabilitation. So, i-compute daan ang ma-receive sa mga creditor under rehabilitation as opposed to liquidation. So, the plan includes the methods to rehabilitate the debtor. Those methods are mentioned in the definition of a rehabilitation plan, katong mga debt forgiveness, etc. So the plan also includes a classification of the creditors. So creditors here are classified whether or not they have voting rights. Voting pertaining to what? Sa may lambutaran. So later on, mag-vote sila on the rehabilitation and the assets that will be utilized to finance the rehabilitation. So just read the important contents of the rehabilitation plan. So during the pre-confirmation stage, creditors will have the creditors meeting. So creditors, they can be convened as a whole, meaning no classification on whether or not they are secured or unsecured, or they could convene per class. So the purpose of the creditors meeting is to vote on the approval of the rehabilitation plan and also to decide on whether they will create a creditors committee. So at this stage, the pre-confirmation stage, the receiver here will work close and the debtor will work closely with the creditors. So all creditors are entitled to receive notices of the meetings and they are required to vote manon. They're required to vote on whether or not they approve or reject the plan. So here's the timeline on the consultation with the creditors. So the receiver, once it knows whether the creditors approve or reject the plan, okay, nagbotaray naman sila, di ba, sa creditors meeting. Then the receiver will notify the court and interested parties of approval or rejection within 5 days from the voting. If approved, that's the time when the receiver will submit the plan to the court, and the court has 10 days to approve the rehabilitation plan. However, even if rejected ang rehabilitation plan by the creditors, the court can still approve that same rehabilitation plan. So what's the test of feasibility of the rehabilitation plan? So this is discussed in many cases pertaining to rehabilitation. So how do you know that the plan is feasible? So there's an emphasis on the conduct of financial studies. So there is a financial examination and analysis, and it should be one of the matters taken up at the pre-confirmation stage. So dapat naa siya, gi-consider siya in the preparation of the rehabilitation plan. So we have specific characteristics of an economically feasible rehabilitation plan in accordance with jurisprudence. So Viva Shipping Lines versus Keppel Philippines Mining. Memorize mo ani guys. Tulo ra man siya kabuk, kaya ra. So how do you know that the plan is economically feasible? If the debtor will have assets that can generate more cash if used in its daily operations than if it is sold. If the liquidity issues can be addressed by practicable business plan that will generate enough cash to sustain daily operations. If the debtor has definite source of financing for the proper and full implementation of the rehabilitation plan. So what makes it feasible? If there is a way wherein the cash flow of the debtor, okay, will be revived. So kung mabalik lang jud to iyang cash flow through the use of assets, through business plans, new business plans, if na ay new financer. So possible ani the stockholders of the corporation, the subscribers of the corporation will infuse additional investments. that can be used by the corporation, the debtor corporation. So these three are the characteristics of an economically feasible plan. So it's also important to consider in the test of economic feasibility kaning gitawag na present value recovery. So one of the purpose of the Fria is to provide for better present value to creditors. So what is better present value? So this is an acknowledgement that at the time of rehabilitation, if given due course by the court, the creditors who have claims against the debtor will not be paid. Okay, di ba? That's the whole point ganing anatay commencement order, stay order, walay creditor na mabayaran. So, why dili sila mabayaran? Because the assets of the debtor will have to be dedicated, okay, to finance the rehabilitation of that insolvent debtor. So, what do you offer to the creditors so that they will cooperate with the rehabilitation of the insolvent debtor? So, you offer them the present value recovery. So, in present value recovery, the present value of the credit, okay, belonging to the creditors, takes into account the interest that the amount of money would have earned if the creditors were paid on time. So, tagaan o interest ang credit sa mga creditors in order for them to uh, be supportive of the rehabilitation. Kay due and demandable na ba ani ilang mga debts, ang debts, di ba? But stay order lang siya tungod sa rehabilitation proceedings. So they are in effect, okay, being compensated for the time that enforcement of their claims are suspended. So the creditors will be entitled to compensation through the earning of interest on the debts that were stayed due to the rehabilitation proceedings. So, knowing the test of economic feasibility, okay, how do you know? When do we say that the rehabilitation plan is infeasible? So, kani, also taken from jurisprudence. If there is absence of a sound and workable business plan, baseless and unexplained assumptions, targets, and goals. Speculative capital infusion. So there is no commitment on the part of subscribers and stockholders to infuse additional capital. The cash flow cannot sustain daily operations, and the net worth and assets, the net worth is negative and the assets are near full depreciation or already fully depreciated. So if these are present, then the plan is infeasible. So creditors committee. Diba, there's a mandatory creditors meeting. So at the creditors meeting, they can decide to form this committee. So this committee are composed of representatives from each class of creditor. So we have the secured creditors, unsecured creditors, trade creditors, and suppliers, and employees. So each of them are entitled to have a representative in the creditors committee. So what's their role? Okay, they will be the ones who will have to work with the receiver in acting as a liaison between the receiver and the rest of the creditors. Because kung wala ning creditors committee and daghan kay creditors si debtor, then pagkagubot na lang, no? And when we start dealing with money, the behaviors of people change. Mahimo silang so mura lang ni sila liaison. And since they are working with the receiver who is an officer of the court, okay, they are expected to maintain order within the ranks of the creditors kung daghan jud kayo sila. So liaison lang ni si the creditors committee ha. The determination of classes of creditors will be the job of the receiver. Siya mo classify sa mga creditors. So the creditor can, however, challenge the classification of the receiver. And this challenge must be brought within 5 days from notice from the receiver of their classification. So again, if nakay dispute with the decision of the receiver, it can be appealed to the court within 5 days from notice. And the decision of the court with respect to the appeal of the receiver's decision is considered as final and executory, but only for the particular issue resolved by that court. So kani nga issue lang sa classification, that will be final and executory. Voting. How is voting conducted when approving or rejecting the rehabilitation plan? So, and how many votes are the creditors entitled to? So, the votes of creditors are based on the amount of their respective claims. And the basis for that will be the registry of claims. So, kung dako kay ka og claim, then you will have more votes compared to others with lesser claim. So, when do you consider the rehabilitation plan as approved? Okay, when members of a class holding more than 50% of the total claims of the said class will vote in favor of the plan. So, simple majority lang siya, guys. More than 50%. Yeah, per class. Okay, per class. When is the rehabilitation plan considered rejected? If it is not approved by all classes of creditors. So what if gi-approve ni secured creditor but wala gi-approve ni employees? Is the plan approved or rejected? Guys, are you there?
Yes, attorney.
Namon to'y upat ka classes of creditors. I-approve ni secured creditor but gi-reject ni employee. Is the plan approved or rejected?
Rejected.
Rejected, attorney.
Okay. So if there is any rejection by any one of those classes, then the plan is deemed as rejected in its entirety. So dapat di ay all the classes of creditors must approve the plan. If one of them will not approve, then the plan is considered as rejected. Confirmation. We are now in confirmation. So hapit na ta mahuman sa court supervised rehabilitation, guys. Taas kayo. Mag-discuss pa ta sa OCRA. Igawas na ba yan sa bar? The OCCRA. So as already mentioned earlier, there can still be confirmation of the rehabilitation plan despite rejection by the creditors. So even if rejected, it's not the end of the game pa. Okay? The court can still approve the rejected rehabilitation plan. So the court can approve the plan as long as the following circumstances are present. The plan is compliant with the requirements of Fria. The receiver recommends confirmation. Okay, the shareholders or owners or partners of the debtor will lose their controlling interest as a result of the rehabilitation plan, and the plan would likely provide the objecting class of creditors with compensation which has a net present value greater than that which they would have received if the debtor were under liquidation. So, compliant with the FRIA recommended by the receiver, the controlling stockholders will lose their controlling interest, and if the creditors would receive greater value than if the debtor would have proceeded to liquidation. So just shorten it because this has also been asked in the bar na. How do you na-ask na ba ni sa bar? Not yet, pero murag kung saan ni siya. Probable nga topic for a bar question. So the motion for confirmation of the plan is filed within 10 days from rejection of the rehabilitation plan. So this power of the court to confirm a rehabilitation plan that has been rejected by the creditors is called the cram down power. Sakto ko na ask na ni sa bar, the cram down power. So this is the cram down rule. So a rehabilitation plan may be approved even over the opposition of the creditors holding a majority of the liabilities if it can be shown that rehabilitation is still feasible. So this is the cram down power or the cram down rule. So is there still a remedy if the court confirmed the plan? So yes, there can be a verified opposition filed within 20 days from notice of the confirmation of the plan. And there are exclusive grounds for opposing the confirmation if the creditor support was induced by fraud, if the document or data relied upon in the plan are materially false or misleading, and if the plan is in fact not supported by the voting creditors. So these are exclusive grounds. So objections or opposition to the confirmation of the plan will be set for hearing as long as they are sufficient in form and substance. Kung dili, it will be outrightly dismissed. If, for example, the objection or opposition is meritorious, will that mean that the plan that the court will retract or take back its confirmation of the plan? So no. If the opposition is granted, then the court will direct the receiver and other parties to cure the defect, provided it is feasible. But if there is a finding that the debtor or any party acted in bad faith and it turns out dili feasible ang curing of the defect, then no other choice on the part of the court. Since di naman siya maka-confirm sa rehabilitation plan due to that incurable defect, then the proceedings will be converted into liquidation. Claro, guys? Take note. So this is another instance when the court will convert the proceedings into liquidation. Katong first instance is after receiving the rehabilitation receiver's report. Di ba? Pwede niya i-convert if what are the grounds nga ma-convert siya at that stage? If the debtor is insolvent but there is no substantial likelihood that it can be rehabilitated. So kani, second time na pwede ma-convert to liquidation. So this is the third important order that is issued by the rehabilitation court, the confirmation order. Unsa tong first two orders that we studied earlier? Commencement
and stay
order, commencement order, stay order, and then we have now the confirmation order. Question, kinsay mag-una? Si stay order or si commencement order?
Commencement
Commencement order. Commencement order, attorney.
Unsa? Mag-una si kinsay mag-una? Balik.
Say commencement. The commencement, then must stay.
Dungan
Hindi niya sila magdungan? Hindi na niya sila magdungan. Ha? Dungan sila or di?
Dungan sila, attorney.
Pwede sa attorney. It depends.
Na pwede sa takawan mo. Once naagay commencement order, part na ang stay or suspension order. Okay, kay unsa may point nga naay commencement nya walay stay order. Di magpataka sila pamaligya, pataka sila enter into contract in fraud of creditors. So, if there is a commencement order issued by the court, okay, it comes with the corresponding stay or suspension order. Magdungan na sila ha. Klaro? But here, the
Yes, attorney.
confirmation order, na nato sa confirmation order, this is the order confirming the rehabilitation plan. And it issues under the following circumstances. Kung walay objection filed within the 20-day period, then the confirmation order is issued. If the court finds the objections lacking in merit, if the basis for the objections have been cured, or the debtor has already complied with the order to cure the objections. So, considering the conditions for the confirmation of the plan, this confirmation order, okay, it issues in the absence of objection or when all the objections have already been resolved. So, di ka ka-issue og confirmation order if there is an unresolved objection. So, there's time prescribed by the Fria, wherein the court must confirm the rehabilitation plan, and that is within 1 year from the date of the filing of the petition. What's the consequence if no plan is confirmed within that 1 year period? Makapag-convert na dayon ka into
Petition, attorney.
liquidation. Okay? Third instance, when there is conversion into liquidation. Kung wa siya na-confirm, if no plan has been confirmed after 1 year from the filing of the petition. So it can be the conversion. It can be upon motion by any interested party, the receiver, or motu proprio by the court. So the court has the discretion to confirm or reject the rehabilitation plan. So question, if there are still unresolved disputes over the claims, can the court still proceed with confirmation? So yes, pwede siya mo proceed of confirmation as long as those unresolved disputes pertaining to a claim of a creditor, okay, are adequately provided for in the rehabilitation plan. So gi-address sa plan itself ang katong disputed na mga claims. On the other hand, the court will reject the plan if it finds that there is no substantial likelihood that the debtor can be rehabilitated, or kung naka-confirm na siya, if the court does that, if it will not confirm the plan, the court will declare failure of rehabilitation. So what's the consequence if there is failure of rehabilitation? Proceed na sad siya to liquidation. So the confirmation order of the court, take note that it should specify the portions approved and portions rejected during consideration or has been cured by the receiver. So it should be specific enough. If there were objections na gi-cure, so the portions approved and rejected are indicated in the confirmation order. So can the rehabilitation plan be confirmed if there are objections from the stockholders or the owners of the debtor corporation, the insolvent debtor? So pwede mo-proceed, okay? As long as it is necessary to restore the financial well-being and viability of the insolvent debtor. So what are the effects of confirmation of the rehabilitation plan? Very important, guys. Kani. The plan will be binding on the debtor, creditors, and all affected persons, whether or not they participated in the proceedings. So binding na siya on the whole world. Second effect, the debtor must comply with the plan and take all actions necessary to carry it out. The payments made by the debtor shall be strictly in accordance with the rehabilitation plan. Contracts and other arrangements not in conflict with the plan remain valid and continue to apply. And then we have the compromise payments and schedule, which are binding on the creditors. And if there are any claims arising after the approval of the plan, these are no longer covered by the suspension order. So let's finish on this slide, guys, and continue next meeting. Taas pa kayo ng Fria, Jud. We're still in court supervised rehabilitation. Right, please type your names in the chat box for the attendance, and I'll see you next week. Any questions before we end? Hello?
An attorney.
Nan attorney.
All right, so see you next meeting, guys. Please read the Fria. Bye.
Thank you, attorney. See you, attorney.
See you, attorney.
Thank you, attorney.